Alrighty, hello there, folks. How you doing? Here I am, and we are going to be talking a little bit about Scott Davis today. Scott has filed a writ for cert, or he's filed cert with the Supreme Court of the United States. He obviously met with some kind of mixed results in the habeas court. The judges were, obviously they were seeing the merit in the number one, the evidence he was trying to bring in, and then there's that which they seem to kind of sympathize with him, but they couldn't do anything about. And then there's the fact of the interpretation of Youngblood, which is also an issue for Stephen. That's what Kathleen Zellner is currently arguing for Stephen in the appeals court, is that the state violated statute by giving the bones back, and then the case law that's going to pertain to it is Youngblood. And that's what's happening here with Scott. So what Scott is looking to point out here is, number one, that he would like somebody to refer this back to the state court so that they will have a hearing so that they can bring in the affidavit of Detective Walker. That's one thing that they're basically asking for here in this writ. But the main part of it is that Scott and his lawyers are wanting to, they are asking the Supreme Court to evaluate Youngblood and maybe possibly, make an adjustment or adjustments to allow for a situation like Scott's, right? Because, and what you're going to see, I'm going to be reading from the writ here in a minute, but what you're going to see is this case. Yes, absolutely it is. So what's going on is obviously with Scott, you guys know there was, originally 72 pieces of evidence or whatever. And when they brought Scott to trial, a great deal of that was missing. Eventually they found some evidence during whenever they found stuff. And so now the count is something like they have 50 pieces of evidence, 50 of the 72 pieces or something like that. And so it's ridiculous. It's ridiculous that they've lost all this stuff. And so what Scott's pointing out is that in Youngblood requires for, a law enforcement, it only evaluates like a detective or a law enforcement officer kind of singularly. And what Scott's arguing is he's saying, look, I'm not saying any one officer did this or had ill intent, really. He said he's basically arguing that the fact that eight different bureaus in Georgia managed to lose the most critical pieces of evidence and were not able to find them, and 8 different agencies lost them. This evidence, this really important evidence that would have helped Scott find out who really did this, right? Because there was blood and DNA or whatever from that they believed was the killers. It didn't match Scott, and they ran away from it. It got lost. It's one of those things that got lost and never reappeared. Okay, that's one. Fingerprints, okay, didn't match Scott. Did they put him into APHIS? No. Did they do any of those things? No. And so what Scott's pointing out is that there's a continual decision-making here that is meant to rob him of his due process. That these agencies, these multiple agencies, are continuously making decisions that rob him of his due process. And that's what he's trying to point out. And he's trying to say he doesn't necessarily think that you can point to ill intent, or that you can point at something specific ill intent, but you can take it from the fact that 8 different agencies were involved in losing this important evidence that there was something going on there, And so that's the questions that he's bringing. I saw Travis say hi. Is he still here? So I'm saying, hey there. Yeah, I mean, and you guys are bringing up Megan. I mean, it's just like, yeah, the blood and the fingerprints are one thing. It's like, oh yeah, those got lost. You didn't want those you didn't want those to get examined by the defense team. Oh, that's interesting. It's just, but then you take the fact that Megan, okay, and this is where Detective Chambers, in my opinion, gets into very hot water, very, very hot water, because Detective Chambers was interviewing, or they were interrogating Scott at the police station. And eventually Scott, he's getting frustrated with them because they're trying to put words in his mouth. They're trying to do all these things and all these tactics that they're using on him. And eventually he just looks at them and says, hey, look, man, I don't know who shot him. Okay? Scott had that information because somebody else gave it to him. So Detective Chambers immediately says, well, I don't even know he was shot. How do you know that? And Scott immediately tells Detective Chambers, because Megan called me and told me. The lead detective was just told that the girlfriend of the deceased had passed this information along to the guy he was interrogating. Okay, so it doesn't stop there, because then Detective Chambers goes out of the interrogation room, out into the little lobby area where Megan is, and where David's friend is also there. And it's one of David's really, really good friends. And so Detective Chamber goes over and he asks Megan, did you say this to Scott? Blah, 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 blah. To which she says, no. She lies. So she just lies and says, no, I never said that. End of story? No, wait. Detective Chambers then walks his little dumb ass over to David's friend, the victim's friend. And he asks this gentleman, did you hear Megan saying this to Scott, about David being shot or shot in the head or anything? To which David's own, the victim's own friend answers Detective Chambers saying, yes, I did. I heard her say that. I heard her, we were standing near her when she said that to him. So there he has instant confirmation that the information was passed to Scott, and that somebody was passing that information to him, had knowledge that he was shot in the head while his body was in a burning house. How could she know? How could she know that? She can't know that unless she was there before the fire was set. She had to be there before the fire was set. Right? Because otherwise, how would she know? If everything's burning, how are you going to tell there's a gunshot wound to the head? It's impossible. So the only way she could know that is if she was there before the fire started. So. Oh, there's Travis. No, you know what I need to do though? I'm thinking I need to get like some shirts made. I don't know. Send like 10,000 shirts. I don't know if I could ever, maybe if I can get together 10,000 shirts with the design on it, with Megan standing outside of a burning house with a little voice bubble saying he's been shot in the head, and just have 10,000 of those sent over to Australia. Anyway, that could be interesting. Yeah, she'll probably see this one and she'll probably get me deactivated in Australia. So all you Australians, you need to watch now. Get in on this now before Megan gets it shut off over there in Australia. Okay. So as I said, Scott Davis has filed cert with the Supreme Court of the United States. And, I hope he has some luck with this. Honestly, I would like to see the Supreme Court maybe adjust Youngblood slightly. Sometimes you don't always have the smoking gun, but you have a great deal of peripheral kind of evidence that something is going on. I don't know. I think it should be taken into account because, officers and detectives and everything, they're all humans and they can make errors. It happens, and it's just like, it's just like with this case, it's so fishy. I mean, when you think about what went missing, and the things that went missing and stayed missing, were some of the most important things. It's just, it's not good. So, anyways, all right. So, all right. So Scott has filed his writ of certiorari. Anyway. And that one. This. All right. Error so clear, reasonable people can't disagree. In deference back to AEDPA. Yeah, well, it may be. So AEDPA seems to be quite a thorn. I know it was created to alleviate certain problems, but I don't think it's working properly, in my opinion. So, all right. So, at the opening of the cert here, it says, this is a case for the court to critically re-examine lost evidence and bad faith under Arizona v. Youngblood. Because in application across various jurisdictions, Youngblood is not being applied in clear and consistent ways. If Davis can present all of the evidence that at this point exists, does the loss, destruction, and alteration of over 72 pieces of critical evidence by 6 separate Georgia agencies that often misled and obstructed Davis and the courts with only circumstantial evidence of guilt qualify as bad faith for the purposes of a due process violation under Youngblood or the 14th Amendment? So what they're trying to say here is that they felt like they had a weak case. At least the way I'm interpreting what they're saying here is that they knew they had a weak case. It was a circumstantial case. And the fact that key pieces of evidence go missing from 8 different agencies there that all had these different pieces of evidence, and they're all losing these critical pieces. Like I said, 50 of the pieces of evidence all showed back up, but the most critical pieces never did. And that's across 8 different Georgia agencies that happened. So what he's saying is that whether it was somebody out to get him, like literally with ill intent towards Scott Davis, or was it law enforcement and agents of the state of Georgia wanting to get a successful conviction without having anything necessarily against Scott, but because they were just chasing the conviction for its own sake? Did they make these errors? Right? For me, it's a fair question. So, all right. So, number 1 question is whether the opinion of the U.S. Court of Appeals for the 11th Circuit is a precedent-setting error in interpreting the requirements for bad faith as a due process violation under the 14th Amendment concerning the destruction and loss of potentially exculpatory evidence under Arizona v. Youngblood that contributes to an existing and growing circuit split of exceptional importance. So what Scott and his lawyers are saying here is that in the 11th Circuit, there's a lack of uniformity. There's Arizona versus Youngblood is getting interpreted in different ways, and there's circuit splits going on. And so what Scott Davis is pointing out is that this is why the Supreme Court needs to address this, because they need to clarify maybe a little bit or something just to clear up some of these circuit splits that are happening because of the different interpretations of Arizona v. Youngblood, right? Hey, JB, what's up, buddy? It's good to see you, by the way. Sorry, I saw you earlier and I wanted to say hi, but glad you could join us at least for a little while. So good to see you. So, anyways, yeah. So that's part of what they're arguing here, is that there needs to be a bit of more clarity for Arizona v. Youngblood. And so that's one way that's one way they're arguing this, so that in the hopes that the Supreme Court will take notice and possibly agree that there is a kind of a divergence of interpretations that they may need to clear up. So that's one thing Scott and his lawyers are putting forward. Other thing here, if the opinion of the U.S. Court of Appeals for the 11th Circuit was not a precedent-setting error of exceptional importance in interpreting the requirements for bad faith concerning the destruction and loss of potentially exculpatory material evidence under Arizona v. Youngblood, should the requirements established by Arizona v. Youngblood be re-examined in light of the various issues of existing circuit splits of exceptional importance, doctrinal incoherence, new forensic science, legislative reform, and state judicial disapproval. So, like I said, what Scott and his lawyers are coming at here, they're pounding on the fact that there are circuit splits. There are different interpretations of Arizona versus Youngblood happening in the federal court system, and so they're pointing that out because obviously that gives more weight to the issues that Scott's trying to bring forward to himself, in the hopes that the Supreme Court will deem it important enough to address it, right? There's a difference between 11th Circuit case decisions and other circuits, and they need to resolve the conflicts. Okay, so Travis is basically affirming what Scott's lawyers are saying. He's saying that the 11th Circuit is interpreting Arizona v. Youngblood in a somewhat differently than the other circuits are. So that's what Travis is saying right here. He's basically saying that the 11th Circuit does need to resolve conflicts because they aren't in line with other circuit courts on this. Okay, so let's go down. All right. So these are what they deem the reasons for granting the petition. See, Davis submits this case should be heard, and that the 11th Circuit and Georgia ruled incorrectly because they interpreted the law concerning the Youngblood bad faith standard incorrectly in a way that discounts objective police knowledge while making subjective ill intent a requirement, and adds to the growing list of circuit splits in interpreting the standard. Let's see here. Unreasonably determined facts of law, while also giving undue deference under USC 42, while apparently focusing on a GASC direct appeal decision rather than the last court to decide the case on its merits, which was the state habeas court. Did not allow Davis's bland Walker bad faith evidence into the record, nor hold the case in abeyance, giving the state courts the first opportunity to hold a hearing. So right now, Scott has got this evidence, folks. He's sitting with this evidence right now. He's kind of stuck. He wants to bring it in, but the Georgia courts aren't letting him back in to bring the evidence in. You know how the appeals court in Wisconsin has kept sending Kathleen back to the district courts with the CD first to bring the CD in. Then they sent her back about the bones so that she could bring the bone evidence into the appeal, right? So what Scott isn't able to do is he's not able to get back to the district courts right now. Nobody's remanding it back to the district courts so that he can bring in his evidence. And his evidence is this. His evidence is proof that there were 2 interrogation tapes, 2 sets of transcripts, 1 for each tape. And for years, the DA in this case, Mr. Howard, Paul Howard, I believe it's Paul Howard. Paul Howard has been saying for years and laughing at the suggestion that there was another tape or anything like that. He's been laughing. Well, now Scott has the proof. The co-lead detective in this case, has issued an affidavit stating very clearly that he originally took over 2 tapes and 2 sets of transcripts, and he gave them to Assistant District Attorney Joe Burford at the time. I mean, Scott has this evidence and he wants to bring it in because it's further proof that the state is lying and being dishonest, and all the way up to the head DA. Right? So he's got this evidence and he wants to bring it in, but he's struggling. No court is holding this in abeyance and sending it back. And that's what he needs. He basically is waiting to get back in so he can bring this evidence in. And he's getting jerked around basically and can't get it in. So yeah, it's wild. So that's where he's fighting right now. He's fighting. He's got new evidence. He's got more things to show that the state is being dishonest. And he's just hitting a brick wall. It's pissing me off because I know Megan is guilty. How could she know a guy was shot in the head while he was in a burning house? How could she know that? She can't. There's no way she could have known that unless she was there before it started. And if she was there before it started, right? So, all right. Number 3, did not allow. Okay, sorry, I did get to that one. This court should grant review to prevent further inconsistent and incorrect application of the Youngblood bad faith standard across varying jurisdictions. All right, so number 1, the 11th Circuit in Georgia interpret Youngblood bad faith incorrectly. The 11th Circuit has apparently never granted a Youngblood claim. Georgia has granted one, but has since strayed. The Supreme Court articulated specific facts that contributed to its holding in Youngblood. So the facts in the Davis case are important. Davis's case differs importantly in many ways from Youngblood, and comparison shows how far the 11th Circuit in Georgia have strayed on bad faith. In Youngblood, the court dealt with the area of constitutionality guaranteed access to evidence in Brady versus Maryland. In Youngblood, there was no question as to whether or not the state complied with Brady and Eggers. The state disclosed relevant police and lab reports to Youngblood, and Youngblood's expert had access to the material physical evidence. Davis is distinguished from Youngblood because not only did the state not provide Davis with all of the various documents, it denied the existence of certain of those documents and lost or destroyed virtually every piece of material physical evidence without Davis even being able to subject any of them to any independent testing or analysis. The essential argument from Georgia on all of the lost and destroyed evidence can be paraphrased as, "Don't know, not my fault, trust me." Yeah. I don't trust you. Your district attorney, Paul Howard, has proved himself to be a liar, so I don't trust you guys. You forfeited trust. In Youngblood, the court concluded that Youngblood needed to show some conclusion I'm sorry, some constitutional duty more than Brady and Eggers. The court cited California v. Trombetta for the proposition that as long as police were acting in good faith and following their normal practice, failure to preserve evidence would not rise to the level of a constitutional violation. Again, Davis is distinguished. None of the evidence was lost or destroyed following normal practices or SOP. Several instances might merely be sloppy, but a wholesale failure to follow customary procedures equals bad faith. United States versus Nebraska beef. In Youngblood, the court found that Youngblood might have had a greater chance of exoneration had the state preserved the evidence than had the state preserved the evidence than Trombetta, but because the state had not attempted to make any use of any of the lost or destroyed evidence in its case in chief, there was no constitutional violation. Again, Davis's case is distinguished from Youngblood because much of the evidence introduced by the state in its case in chief was related to the lost or destroyed material physical evidence. So what they're saying there, folks, is that so they're basically saying the state got to examine all of that evidence and prepare all of its reports back in 1997 when this went down, right? And the state got to prepare all those reports. And so the state got to bring out all that analysis that they did of the evidence back when this happened, right? So they were able to bring all that into court, no problem. They were able to go and pull those old lab reports and all that stuff and all that, everything, all the examination that they had done, and they were able to bring that into court. Scott Davis and his attorneys, they were just sitting there like, what can we do? It's all gone. We can't look at it. We can't test it. We can't do anything. We can't do anything with it. It's gone. And before trial, it's gone. I mean, so yeah. To me, to lose that much evidence and for it to be the most obvious. I mean, you can't. There's almost no way to argue that the blood isn't exculpatory, because we know they thought it was the killer's blood, and we also know that it didn't match Scott. That's why it got lost, right? We know it didn't match Scott. Chambers did go as far to make sure whether it matched Scott or not, but when it didn't match Scott, it scared him. And it got put away and eventually lost. The fingerprints, same thing. So, I mean, these are huge pieces of exculpatory evidence that have been lost, that the state was able to bring in all their examination and talk about all their examination, but Scott and his lawyers were left up S Creek without a paddle. You know what I mean? All right. Let's see. Unlike Youngblood or Trombetta, Davis's case rested entirely on circumstantial evidence, including the state's characterizations of the one-sided tests ostensibly performed on the missing evidence. Right? Because the state was able to do, like I was just saying, they had done their examinations of all this evidence back in 1997. And by 2005, all the evidence, the most critical pieces of the evidence were gone. Bye-bye. Still haven't been found to this day. Also, unlike any of the cases cited by the court in Youngblood, Davis has no viable alternative means of demonstrating his innocence. Davis's best chance was to find an alternate suspect, and that was foreclosed by the state's loss and destruction of all the evidence that could have done this. The state took 10 years to bring Davis to trial, and somehow 6 separate Georgia agencies lost or destroyed virtually all of the material physical evidence, over 72 pieces. These 6 agencies violated over 300 of their own SOPs along the way. The standard set by Trombetta is that the police have to follow, have followed their normal practice. Violating over 300 of their own SOPs cannot be considered normal practice and must violate Trombetta and Youngblood. In a statement in Youngblood that has lent itself to grossly varying misapplication, the court said bad faith is shown in those cases in which the police themselves, by their conduct, indicate that the evidence could form a basis for exonerating the defendant. So in other words, unless a cop actually says, oh, this could be helpful to the defendant, we better lose it. Unless you catch him saying it or catch the smoking gun. So that's what that is. Davis did not discover that some physical evidence had once existed and been collected by the state until he was litigating his state habeas corpus case. He was finding out about evidence after his trial at his habeas case. These revealing discoveries made during this initial collateral challenge provide much of the evidence of the state's bad faith. The most important and misapplied part of Youngblood is undoubtedly the following. We therefore hold that unless a criminal defendant can show bad faith on the part of the police, failure to preserve potentially useful evidence does not constitute a denial of due process of law. The presence or absence of bad faith by the police for purposes of the due process clause must necessarily turn on the police's knowledge of the exculpatory value of the evidence at the time it was lost or destroyed. Well, by that argument, we know that Detective Chambers, we know that he believed that blood was the killer's, and we know that he knew it wasn't Scott's. We also know Detective Chambers went out and asked if Megan had said that had said to Scott that David had been shot or shot in the head, to which he heard from David, the victim's friend. Yes, he had heard Megan say that. Also that friend's girlfriend was there. She also heard Megan say it. Okay? So you have these issues that Detective Chambers has willfully ignored. And that's what the affidavit from Detective Walker helps to put in clearer leaf or in sharper leaf, because it's one of the lead, it's the co-lead detective, okay? Chambers and Walker were the co-lead detectives in this. Walker has issued an affidavit now spilling the beans. There was 2 tapes and 2 sets of transcripts. Okay? And so if Scott can get his evidence in, he can show that the state was playing games and being dishonest, which to my mind suggests that they knew. And that evidence disappeared for a reason. They were able to find 50, but those other 22, particularly blood and fingerprints, those are gone. Bye-bye. Never to be seen again. I'm glad to hear you say that, Trav, because I can't believe that they got rid of the blood and the fingerprints, that they allowed that. I mean, it's not like it was a long time. Seriously, from 97 to 2006. I mean, we're looking at 96 to 2006. I mean, we're talking about 10 years. And this stuff was getting lost before trial. Before trial. I mean, yeah. All right. Their focus is on knowledge and conduct in defining bad faith, but no mention of a requirement for official animus or ill intent in Youngblood. Youngblood discusses bad faith without using volitional words like intent and purpose. Yet subjective ill intent is exactly what Georgia and the 11th Circuit require. Their requirement for proven animus or ill intent is unreasonable because it is not the character of the prosecutor, but the character of the evidence that most matters. Clearly, bad faith is present when state agents lose or destroy evidence with official animus or conscious effort to suppress, but bad faith is not necessarily absent when state agents lose or destroy evidence and independent proof of those specific motives is lacking. Ill intent may be one way to prove bad faith, but it is not the only way. And this variance concerning ill intent goes to the heart of the various jurisdictional splits on how youngblood and bad faith is interpreted. Okay, there they go. Back, folks, tying it all back in. Everything they were saying about Scott's case, but at the end, they tie it all up into a bow, talking about how this is all, for all these reasons, this is why it has added to and contributed to these circuit splits in interpreting youngblood. So that, I mean, they're taking it, they're making Scott's case, right? They're talking about what's going on with Scott's case, but they're always wrapping it up in that bow at the end of this, where they're reminding the court, this is why there are so many circuit splits, because wanting to resolve circuit splits is something the Supreme Court of the United States, that the Supreme Court of the United States actually takes pretty serious. That's a reason that will maybe incline them to take this case. And so that's why his lawyers are continuing to bring that back around. So an objective evaluation of bad faith is required. There is ill intent in the conduct of the Georgia agencies that lost and destroyed evidence in this case, but this is not the only evidence of bad faith. When we no longer have the evidence that a defendant was not allowed to analyze, courts cannot just blindly trust the 6 separate law enforcement agencies in the Davis case that lost and destroyed evidence to give us their honest and subjective view of their knowledge or conduct when they are the ones that are at risk of being blamed. Right? They're not going to come out and be honest because they don't want to be responsible. That's what they're saying right there. They're not going to come out and say it because they don't want to be held responsible. So that we're not likely to get them telling the truth. So they're motivated to want to hide anything like that because they don't want to be held responsible. Let's see here. Evidence of bad faith is likely to be within the peculiar control of the police, and an officer unprincipled enough to destroy evidence is unlikely to chronicle his actions. The defendant is ill-suited to inquire into subjective good faith or bad faith of the police. The most relevant evidence of police good or bad faith is apt to lie within the control of the police. The police officers are highly unlikely to cooperate voluntarily with the defendant by accusing fellow officers of misconduct. So it's coming back to the all compasses point north, folks. They're all gonna jump in and support each other. That's the way law enforcement officers work. I know some people have a problem with that. I understand why they do that. I understand how that happens and why it happens, but there's also a point that gets reached where they abuse it. It does happen. But all compasses point north. They just all seem to agree, and they all tend to go along with each other and everything. Or when the order comes down from the top, everybody falls into line. That's what I mean by all compasses point north. They all just tend to be of a similar attitude and frame of mind, and tend to go, and tend to think along the same lines. And that's why I say all compasses point north. So courts should instead use an objective evaluation that is at a minimum based on the knowledge a professionally trained officer, agent, expert should have, and how she should have evaluated and preserved evidence that was at least initially viewed as worthy enough to collect and worthy enough to convict, especially where clearly defined SOP is present. SOP is standard operating procedure, folks. Again, another thing I point out about the Avery case is that so often SOP was just left behind. It doesn't make sense for law enforcement to break with standard operating procedure as many times as they did in the Avery case. Because the reason why officers follow standard operating procedure, folks, is because it gives them basically, if they do it the way, if they do what they're supposed to according to the rules, then even if something really bad happens, they don't get held accountable because they were following SOP. Okay? They put themselves at risk when they don't follow SOP. So you understand how that works? They're actually putting themselves at risk when they don't follow standard operating procedure. Just like Scott Davis is saying here, because these agencies didn't follow standard operating procedure, they have opened the door to this inquiry. Right? And it's the same thing. There's no reason for law enforcement officers to abandon SOP. I mean, there may be some reasons for it to happen on rare occasion, but not the multiple times, many times that we see it happen all throughout Avery's case and all throughout the evidence with Scott Davis's case. It's cops don't do that. They don't just ignore standard operating procedure, something that protects them. Okay? It's a very rare occasion when they decide not to follow standard operating procedure, and there's usually going to be a very, very specific reason why. So it just doesn't make sense that it happens so many times in one case, Avery's, or one case, Davis's. So let's see. Secondarily, it is reasonable to infer some evidence of this knowledge based on the appropriate or inappropriate conduct of officers. Oh, it is reasonable to infer some evidence of this knowledge, right? As in this case, pervasive inappropriate conduct and SOP violations by trained and certified law enforcement is strong evidence of bad faith, because it is an objective way to show that the police had knowledge of the exculpatory value of the evidence. Simply said, it should not be accepted by courts when an officers say, "We have clear SOP, but it's okay if we ignored it." The 11th Circuit ruled that there is no evidence that departures from protocol were coordinated or designed to deprive Davis of evidence expected to play a significant role in his defense. Really? How about not running the prints through APHIS? How about not running the DNA through SCOTUS? They're deliberately dropping the ball. Because they don't want, they have a very, very circumstantial case against Scott. And if they turn up something that points at somebody else, their case is going to be shot. How's that for a motivation? Fulton County. Yes, that's true. Yes, Travis, you're right. Fulton County. This is not only wildly inaccurate reading of the facts as contained within the record, but it also requires the notion of an official collusion and intent standard, coordinated or designed, that is nowhere to be found in Youngblood. The facts show 6 separate Georgia agencies intentionally preventing Scott Davis from testing or accessing evidence by destroying or withholding it. Fingerprint cards, secret second intertape of the interview, coercing a falsified affidavit from Linda Tolbert at Atlanta Fire, perjury, forensic reports from a fired and disgraced GBI expert, etc. While committing over 300 SOP violations, this collective knowledge and conduct show the state knew of some exculpatory value of this evidence and was dishonest about it, or why do things like coerce a false affidavit? Fair enough question. I mean, that's a fair question. Why is the state doing all these other things proactively? Why are they coercing somebody into a false affidavit? Why would they need to be doing those things? Right. Without any admission of intent from police, which don't come for almost 20 years in this case, proof of bad faith can only come from an objective evaluation of the actions of trained, certified law enforcement. It was discovered during the state's habeas proceeding that the FCDA coerced an Atlanta Fire employee, Linda Tolbert, to provide a false affidavit concerning 35 pieces of material evidence that disappeared from Atlanta Fire that included the alleged murder weapon, intentionally deceiving Davis's attorneys. Evidence handling expert Captain Robert Doran testified that there was a pattern and practice of police agency, fire department, GBI laboratory, and prosecutor's office of failing to respond timely to deficiencies in the chain of custody, handling, retention, and disposal of physical evidence associated with this matter, and that the pattern and practice did not comport with commonly accepted professional law enforcement standards. So, again, doing things shadily, doing shady things, right? As if it were not bad enough, the state failed to disclose information to Davis about the lying, disgraced, and fired GBI firearms examiner Bernadette Davy, whose analysis and opinions had been used in Davis's case. This failure and Davy's criminal behavior in her official capacity further impeached the state's purported testing of evidence and credibility in triple fashion. This was not a mere mistake, but direct bad faith conduct. Davis argues that, as in circuits other than the 11th, in manner similar to United States versus Elliott, the United States versus Estefani Zaragoza Moreira, Ninth Circuit, police's knowledge of potential exculpatory value of the evidence at the time it was lost or destroyed must be objectively evaluated based on the reasonable standards. So that's the way that the Ninth Circuit is doing it. These objective standards should evaluate police knowledge based on the fact that they are professionally trained law enforcement professionals certified in collection and preservation techniques and SOP. They are not civilians. Courts often give law enforcement personnel extra credibility because of this specialized professional knowledge. This knowledge should also be objectively evaluated as to the collective system at large knowledge that the system itself should have had. In this case, 6 separate agencies were involved in losing and destroying evidence. Such systemic misconduct and incompetence cannot reasonably be objectively evaluated as anything but proof of bad faith. This was no act of God or single incident. The lost destruction was perpetuated and allowed by dozens of officers, agents, experts in multiple locations. At least one of these state employees should have prevented it if they had exhibited any reasonably objective professional care in a wholly circumstantial case. High-profile murder case, in a wholly circumstantial case, high-profile murder case, especially where Davis had repeatedly maintained his innocence. The failure of the state's prosecution team to act to protect the evidence from loss or destruction must also be evaluated based on the current forensic standards of that time. Most of the evidence apparently disappeared in 2005. Literally, in the year leading up to his trial, folks, most of the critical pieces of evidence disappeared in that year when they were getting ready to retry him. Coinky dink? No. Let's see here. Advanced forensic technologies, including PCR, DNA testing, touch DNA, millions of prints in the APHIS system, and CSI-style technologies were common, unlike in 1988 when Youngblood was decided. These technologies provide higher possibilities of materiality because they can identify suspects in more ways and with greater certainty. The unchallenged fact that 6 separate agencies lost and destroyed evidence is inculpating of the state on its own. It should be manifest that so many separate agencies could not accidentally lose or destroy so much evidence, or if they did, and to have chosen so specifically the ones that would have been most helpful to Scott. I mean, it's anyways. Or if they did, the entire system was constitutionally deficient in Georgia and was so far beyond recklessly negligent, or was so far beyond recklessly negligent that it qualifies as de facto proof of bad faith. One specific example of bad faith that deserves emphasis is the fact that the GBI and Fulton County prosecutors lied and obstructed concerning the key crime scene fingerprints in the case. They were tested and not Davis. And that there existed 2 different sets, not one, of the 6 fingerprint cards that were both destroyed, lost independently with no digital backups, directly contrary to established SOP. The fact that they didn't preserve the fingerprints is a violation of SOP right there. That's one. It is highly improbable that this destruction of evidence which occurred right before Davis's indictment in October of 2005, 9 years after the crime, was coincidental. Yeah, it is hard to believe that that's coincidental. It's extremely difficult to believe that. This is especially true since the FCDA was trying to match the prints to the victim unsuccessfully. In January 2005, by the GBI's own SOP, the prints were APHIS quality fingerprints that prosecutors were so keen to try to use to convict Davis within 1996, but yet were never run through APHIS for over 9 years. Again, the fingerprints in this case were Davis's only chance to identify another suspect. That and the blood. This was also a violation of Georgia law. Law enforcement agency or a prosecuting attorney shall maintain any physical evidence that relates to the identity of the perpetrator of the time. It is also not reasonable to claim trained law enforcement did not have the knowledge to see the apparent value of crime scene fingerprints that were not Davis's. Right? Once they know they're not Davis's fingerprints, them disappearing seems fishier. And without being run through APHIS, the fact that they disappear without being run through APHIS after they don't match Scott shows an intent to want to make them go away so that they can't come back and cause problems. The opinion of the 11th Circuit, if it stands, as Glenn Cunningham once discussed in the Baylor Law Review, would effectively provide law enforcement officials with a blueprint to convict the innocent, because police now have little incentive to preserve potentially exculpatory material. In fact, police now have arguably been given a green light to destroy evidence without fear of having to suffer the consequences of their conduct. It appears police simply just need to obstruct at least until after trial, and Georgia courts will allow it under any excuse. A collective, we don't know, we didn't do it, should not be good enough because they should have known and they shouldn't have allowed it. As Justice Stevens stated in Youngblood, there may well be cases in which the defendant is unable to prove that the state acted in bad faith, but in which the loss or destruction of evidence is nonetheless so critical to the defense as to make a criminal trial fundamentally unfair. How can at least 70 material items collectively not be critical? The defense doesn't get to examine or look at that, any of it really, and certainly not the most important pieces. The prejudice of all the missing and destroyed items made Davis's trial fundamentally unfair, and I agree with that, especially when you consider it's a completely circumstantial trial. The case is completely circumstantial. Okay, so Youngblood is due a critical re-examination. 3 decades after Youngblood was decided, it is past time for a critical re-examination of its holding. Youngblood was built upon the conviction of an innocent man. First, forensic science, including DNA, was nascent in 1988. Since then, there have been remarkable advances in many areas. Evidence that basically they're just arguing that there's been advances since Youngblood was decided, and that the court needs to go back, take a little closer look at this, and give clarification on it, right? That's mainly what they're getting at here. So here they are talking about the Bland Walker. This is the Bland Walker new evidence. Walker is the detective that is now, has now issued an affidavit, stating clearly that there were two interrogation tapes and 2 sets of transcripts, despite the fact that Paul Howard has been stating for years that there was only one, and he was just laughing at anybody that tried to suggest that there was 2. So very, very disturbing stuff. So that's what Scott's trying to do, folks. He's hopefully the Supreme Court will look at this and will kind of give a clarification on Youngblood. And then hopefully then he can maybe have the 11th Circuit look at his case and evaluating it under the new standard that they will find bad faith on the behalf of the state of Georgia, which is what he needs. So, all right. Here's the conclusion. Something is rotten in the state of Georgia. Yeah, I agree. I definitely agree. No criminal case in state or federal jurisprudence has been found that compares to the losses in this case. The cumulative nature of the actions and inactions of the state actors related to the material evidence lost, mishandled, destroyed, or concealed over this case, even without considering the Bland Walker evidence, qualifies as bad faith and knowledge for Youngblood purposes under the totality of circumstances standard. Evidence of the state's bad faith for Youngblood purposes is overwhelming when the Bland Walker evidence is considered. If a reasonable jurist actually looks at the facts in the record pointed out in the objections, in this case, rather make excuses for every state transgression while repeating the incorrect factual claims often used by the state, not supported by the record, the bad faith and misconduct should scream due process violation because the state court's determinations of fact and law were objectively unreasonable. They should not be entitled to deference by the federal courts. If the denial of Davis's Youngblood claims stand in this circumstantial case, where there is significant evidence Davis is actually innocent, it would set an impossible burden to meet for any defendant and would allow the state to destroy and lose evidence at will with no consequences while violating the due process clause of the 14th Amendment to the United States Constitution. Youngblood should be critically re-examined. When it comes to the constitutional right of access to evidence, it is time to end Youngblood's myopic focus on bad faith and instrumentalism to the detriment of an alternative vision of due process that promotes adjudicative fairness. In this case, as the district court noted, a reasonable jurist might conclude that the cumulative pattern here indicates the petitioner was denied a fair trial. It doesn't just indicate it, it screams it. Davis praised this court issue writ of certiorari to examine the questions posed and grant such relief as warranted. So that's the gist of it, folks. That's basically what that's the writ. Hopefully the Supreme Court is going to hopefully the Supreme Court will look at it, and hopefully the fact that there's circuit splits will cause them to not only accept cert, but to actually analyze it and give a decision and further clarify Youngblood, hopefully at some point. So hopefully that's what we'll see. Okay, so that's where Scott's at. Folks, I just am so pissed off at where he's at. Clearly, Georgia doesn't want to let him back into district court so that he can bring in his evidence. They just feel like he's in prison. He's expendable. Who cares about Scott Davis? They'll just keep him pinned into this little limbo where he's at, where he can't bring in his new evidence. He's just kind of stuck without footing, and they're content to leave him there. They should be holding a freaking hearing so that they can see Detective Walker's affidavit. So for me, the state of Georgia is covering their butt right now by refusing to grant a hearing to allow Scott to bring in that affidavit. They are obstructing. They don't want that to come in because they realize that comes in and that makes the entire state of Georgia look bad, because all the law enforcement agencies, all the agencies involved look bad. And so the state of Georgia has a vested interest in keeping Scott fucked. Sorry, I don't like to cuss, but in this case, it applies in spades. So that's where we're at. Hopefully, hopefully Scott will get some purchase here. Hopefully hopefully, if nothing else, hopefully SCOTUS gives him a way to get his evidence in. Maybe they send it back to the district court like none of these other courts have been willing to do. Maybe they'll send it back and say, hold a hearing regarding this. I don't know if they can. I don't know if they will, but it's pretty screwed up the way that the state of Georgia is doing Scott Davis. They know they floated it over the net, and now they're just going to desperately try to do everything they have to do to hold on to him, because they know that they were doing some pretty shady shit to convict him. So, all right, folks. It's the end of the month, fortunately, but I am just about at my 20 hours for the month on StreamYards. That's right. They only allow you 20 hours a month. So I'm approaching that mark now. So I'm going to have to go ahead and shut off, but no worries. By Wednesday, I'll have a fresh 20 hours again. So no worries. We'll be able to go live. So, all right, folks. That's the little update on Scott Davis, folks. Share this video. Tweet this video. Tweet and share about my other ones. Make it known, what Megan is up to, what she's done, the things that we know that she shouldn't have known, that we know about her that she shouldn't have known, all those things. I really want to help Scott, folks. I mean, unlike Stephen and Brendan, he doesn't have a documentary to get people excited about his case. He's just got Erekose and some other folks out there. But it'd be a whole lot different if he had a documentary like Making a Murderer, so we could get more people making noise for him. But I know a lot of you that are here that have hung with me during this live. I know you guys care about it too. I know you guys feel this case too. So get out there and share. I will share your COVID video. Yeah, you can share my COVID videos. Absolutely. Share any of my videos you like. Absolutely. We did one about COVID yesterday with Rule and McGilla and Paul. So if you guys haven't seen that one, check it out. And all right, folks, if you haven't already, please hit subscribe, and we'll see you.